Assalamualaikum. My name is Syamil bin Suhaimi.
My name is Izzat Yusihan.
Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Fafur Razi bin Luqman.
Assalamualaikum. My name is Muhammad Solihi bin Yusuf.
Assalamualaikum. My name is Muhammad Azim bin Jasar.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. Before we proceed to the critical part of the question for today, I would like to give a brief explanation on introduction of Employment Act 1955. In general, this act may be cited as Employment Act 1955 and it should apply only to West Malaysia. In general, there are two purposes of this act. First of all, it is to provide number of minimum benefits for those workers covered by this act, for example, maternity leave. And for the second purpose is to establish certain rights for both employers and employees in terms of contract of service and others. So, in general, you can say that it is an act which regulates the operation of the labour market in general and the employment relationship, employers and employees in particular. For example, it includes hiring process, suspension from work, maternity rights, layoff and wages.
Women have been making significant contribution to every aspect of Malaysia's development, especially in social, cultural and economic sectors. Currently, Malaysian women play a greater role in the labour force both in the professional and non-professional sectors. However, some women in Malaysia, as in other countries, have had to encounter institutional and social barriers as they struggle for equality of opportunity in the labour market. For the employment of women, the Act mostly concerned on working hours and maternity benefits rather than discrimination and equality of pay. An employer may not permit women to work between 10 p.m. and 5 a.m. in industrial and agricultural undertakings and shall be given rest 11 consecutive hours before her start the new section 34 clause 1.
A pregnant woman who gave birth after 2 months working for an employer is not entitled to maternity allowance. The law says it must be at least 90 days. Women workers in the private sector are given 90 days maternity leave, while in the public sector are given 42 days maternity leave. All are given leave for 5 surviving children. There are also provisions prohibiting an employer from dismiss woman when she is pregnant. For maternity protection, provided in that every female worker, married or unmarried, is entitled to maternity leave period for not less than 60 consecutive days. In respect of each confinement under Section 37 Clause 1 Clause A and under Section 37 Clause 2, shall receive the maternity allowance from the employer. She will not be entitled to maternity allowance if at time of confinement she has 5 or more surviving children.
The first issue is maternity leave. The question is, if the maternity leave is granted, will it be paid or unpaid? Second, the question, if the paid maternity leave is allowed, how much should a mother on leave is paid? Lastly, the issue of job security, that is, whether or not they will be able to return to the same organisation, same position due to the long leave. It is true that Employment Act does provide that employer cannot terminate the contract of employment for a woman who is taking the maternity leave. However, they have right to replace the position for the organisation benefits. So, what will happen to the woman if she is demoted to the lower position or transferred to other department or position? Will there be any statutory protection to prevent this from happening? The third issue of women protection is the presence of sexual harassment. Sexual harassment is a serious problem. It's not about mutual attraction or flirting, but abuse of power. Sexual harassment occurs in sexist environment where women are devalued and remarks, and all gestures targeted at women are considered natural and acceptable. This intolerable social behavior creates a hostile working environment which has real implications on productivity, efficiency and employee turnover, and can also result in stress and...
Our recommendation for the first issue is, in Malaysia, if the maternity leave is granted, it will be paid 100% of the full 60 days of the maternity leave. In many countries, the worker's reinstatement in her former work is automatic and she resumes her post at the end of her maternity leave. The entitlement may also be subject to certain formalities, such as period notification. In the absence of relevant statutory provision, such formalities are sometimes defined in collective agreements. In the Bahamas, for example, a collective agreement covering the hotel and catering trade stipulates that the employer must be notified of the worker's intention to return to work within 6 months following the birth. Failure by the workers to give such notification may be interpreted by the employer as meaning that she does not intend to resume work and give the employer the right to terminate the employment. In certain cases, the right to resume work is subject to a medical certificate stating that the worker is fit to do so. A written Our recommendation for the third issue is, sexual harassment case were thus handled by the police. To curb sexual harassment in the workplace, it was obvious that employer had to play a role. This led to the introduction of the code by the Ministry of Human Resources in 1999. The code served as a guide to employer for establishing and implementing a preventive and redress mechanism for sexual harassment.
Assalamualaikum. Contract of Service. Section 6 and 7 of Employment Act stipulates that the definition of contract of service, it means any agreement, whether oral or in writing, and whether expressed or implied, whereby one person agrees to employ another as an employee and that the other agrees to serve this employer as his employee, and includes an advertised contract. According to Section 8 of Employment Act, contract of service shall not contain any condition that restricts right of employees to join, participate in or organize trade unions. Next, according to Section 11 and 12 of Employment Act, a contract of service must contain a provision for its termination in the absence of any agreement to the contrary. Period of notice for termination of contract shall be as follows. First, 4 weeks notice if the employee employed for less than 2 years. Second, 6-week notice if so employed for over 2 years but less than 5 years. Third, 8-week notice if so employed for 5 years or more.
Retrenchment is one of the elements in the contract of service. The definition of retrenchment according to Department of Labour, Malaysia, retrenchment means termination of the contract of service of the employees in a redundancy situation which arises from several factors such as closure of business, restructuring, reduction in production, mergers, technological change, takeover, economic downturn, and others. The issues of retrenchment during Asian financial crisis in 1997 and 1998. During the financial crisis between January and December 1998, the total number of workers retrenched was 83,865. Based on the data collected from January to September 1998, almost 88.1% of or 52,834 of workers were retrenched. Now we go to the recommendation.